Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're continuing on with our discussion of what happened in the Cockerham case. I'll have more in just a moment. Before we get started too far here, I want to make sure everybody understands this is talking about one case. This is not how American Family acts in every case. Most of the issues that were caused in this case were caused by the lawyers, not the insurance company. So if you'll recall from the last video, where we are back in the trial court, the place where we left in order to go to the appellate court. The Court of Appeals sent it back to the trial court and it said enter judgment and conduct additional proceedings consistent with this opinion. Now I have to admit, at the time that it was remanded, I thought that meant a trial on vexatious refusal because there were facts left to be determined. But as you'll see, that isn't exactly what happened. So what happened was we filed a motion for judgment. Basically, we said to the court, hey, Court of Appeals says we win, we get judgment, issue judgment for the admitted damages. And American Family came back and said, whoa, wait a minute, you can't do that. What are you thinking? No, the Court of Appeals only said they got coverage. Well, that's not what the Court of Appeals said. What the Court of Appeals said is give the guy judgment. But apparently that just wasn't registering with American Family. So they fought us tooth and nail on whether we should have judgment. So we got at least one oral argument in, and then they filed additional paperwork. We had a second oral argument on this, and the judge issued an opinion. He said, plaintiffs are right. Court of Appeals gave them judgment. And this is from the actual opinion written by the judge. It said American Family put all its eggs in one basket, that the courts would agree with it, that it had no coverage, rendering it unnecessary to dispute homeowners' evidence of damages. Unfortunately for American Family, the Court of Appeals did not agree with its position on coverage. Accordingly, the uncontroverted evidence of damages is the amount set forth in the Madden affidavit, and there is no material fact in dispute on the amount of damages. Under the mandate, homeowners are entitled to judgment as a matter of law, and that judgment includes money damages. The trial court went on to say, it is therefore ordered, adjudged, and decreed that as to count one of the petition, which was the breach of contract against American Family, judgment is hereby entered in favor of plaintiffs and against the defendant, American Family Mutual Insurance Company, in the amount of $845,292.36, which includes $475,000 in actual damages, as well as prejudgment interest in the amount of $369,926. And pursuant to that statute, the judgment shall bear post-judgment interest at a rate of 9% per annum until full satisfaction of the judgment amount. And obviously the difference there is the increase based on the prejudgment interest. We thought that would mean that we would get to set the case for trial on vexatious refusal. But right as the court was getting ready to set the case for trial on vexatious refusal, American Family came back and said, Judge, you need to hold off because we're going to take a writ. Well, the writ that they're going to take is the writ of prohibition. And in Missouri, what that basically means is that a judge has exceeded his authority. He's done something beyond which he was authorized to do. And basically the argument they made was the mandate only provided for coverage, so when he issued this judgment, it was outside the bounds of his coverage and it needs to be vacated. So that was filed on August 2nd of 2019, so we're already a year past the point in time where we won at the appellate court. It took us a year to get there, and they filed this writ on August 2nd, and on August 5th, the Court of Appeals denied the writ. So you can imagine that it didn't land there with a great deal of interest on the part of the court in helping them out, because I think the Court of Appeals was pretty clear on what it did and what it meant to do. So that's what happened. So at that point, it came back to the trial court, and we again started to get ready to get this case set for trial. And instead, what American Family did, as we started filing motions in limine, which keeps out evidence, and other things, experts and that sort of thing. And what happened there was that American Family came back and said, whoa, wait a minute. They're saying that the judgment counts for something. We don't think the judgment counts for something. So we want to be able to contest damages at this trial. And the court was like, no, that's not going to happen. So they filed a motion to set aside the judgment. And basically what happened there is the trial court, after listening to the oral argument on that, said, look, you're arguing the same things you argued before the judgment was entered. You're arguing the same things you argued to the Court of Appeals on your writ. And now you're arguing it again. It's the third time I've heard it, all these things. Nothing has changed. You lose. Well, I'm a pretty even-tempered guy. But when you continue to run me around the mulberry bush, I get a little ticked off. And so I went and I started doing legal research, which is really a good thing for a lawyer to do. Because I found these cases that said when an insurance company refuses to pay a judgment after it's been entered or after it's been determined that they have no meritorious defense, that's the definition of vexatious refusal. So I filed a second motion for summary judgment. And again, American Family contested that, saying, no, we have to have a trial on that. And the judge said, no, he's not, the American Family, they are not asking for judgment on the prior claim. They're asking only for summary judgment from the point in time when the appellate opinion made sure that you had no meritorious defense. And by the way, it's been over a year now. So the trial court issued judgment for us on the vexatious refusal claim. Now, in the next video, I will be going over what happened at the appellate court when American Family appealed that judgment. So, thank you for watching. I hope you found this interesting. If you have any comments, please leave them in the comments down below. If you haven't already, please go over here and subscribe. Tap the notification bell so that you will get all of the notifications whenever we release a video here on this channel. Thank you so much for watching and have a terrific day. I'll catch you on the next video, which should be released in a couple of days.